you're running a generic business, nearly every locality, whether it's a medical marijuana related business or not, nearly every locality, county or municipality requires you to file something to do that business. You file that thing depending on where you are, a business license, Denver requires an occupancy license, they may require some type of kitchen license, although the state does say it's not food. So whatever the local requires you to do that, and then just do more. File a ton of stuff, make sure that it's date stamped by June 30th. And I don't want people to miss the deadline here. My interpretation of the actual deadline is June 30th, not July 1st, because the law does say on July 1st, be operating the business. Don't wait until July 1st. Get it done by June 30th. Don't get caught up in that one-day thing. A couple of people in Denver got caught up in that. Some of you were here, that March 1st, February 28th conundrum. That's my advice to you. It is not a perfect situation. I mean, the Department of Revenue is still figuring out the details of this, but one of the things that is inflexible from their perspective is that deadline of June 30th being either a locally approved business or at least having on file applications to do that business. And every locality has some generic requirement for businesses. Follow those, and then you've got some hope. If you blow those off, by contrast, I mean, you're just out of it for months and months and months until the government tools up and gets this process going. The state legislature built this in to allow you to continue to do business if you are in business. So that's kind of an imperfect answer, but that's the best we can, the best I can do.
And I agree with you, Bob, for the record. Thank you for that.
This is good. You said that there is a lot of bad information out there, and a lot of us have dealt with that. You just said a minute ago that as a grower, you must be affiliated or connected to a dispensary. So basically, my question to you is, as a grower, do you have to be an owner or have any ownership in a dispensary to be a grower? Or can you connect that to a contract or arrangement in other terms?
The answer is actually statutory. And the bill says in order to get an optional premises license, optional premises cultivation permit, you must be licensed with either a center or an edibles manufacturer. And so that person who's licensed has the ability to get the optional premise grow license. Does that answer your question? Thank you.
Okay, go ahead, sir.
My question is it on? My question is from Matt. And you stated that, yeah, you're the winner tonight. So you stated that with the funds being generated out of the MMCs, that certain monies have been earmarked for your organization. I was just wondering if there was other programs that have been put on the books, let's say, or in the budget that have been earmarked for within that budget. Specifically, let's say, patient programs or anything like that.
HB 1294 does provide that the first $2 million, I believe, of tax collections will go to that type of an organization. The license fee specifically will go to pay the costs of the regulatory functions for the industry itself.
1 second. Excuse me, guys in the back. If I can ask you to keep it down a bit while we get through this session, please. There is room in the lobby if you need to have several conversations. Go ahead with your question, sir.
Yes, I'd like to follow up on the relationship between the dispensary and the optional growth facility. Does that relationship, can that relationship be contractual? Does it have to be ownership?
It does have to be ownership. I mean, license, in order to hold the license, you have to be the owner.
And does that ownership have to be 100%?
However you, well, let me give you a scenario, because it's, and you're really asking a question a lot, you should probably talk to a business lawyer, but as an example of something that might work, you and I, you may have a dispensary, I may have a grow, we can create a partnership, and the partnership can hold both of our licenses, and we can decide amongst ourselves how we distribute the profits. Pursuant to a partnership agreement. My question is, regarding the 70 70-30 ratio, I've heard rumors, we've heard legal opinions, and I know that this is still subject to some of this rulemaking process, but I've heard that 70-30 is an inventory thing, it's a daily thing, a monthly thing, and then you said you have to certify that you're growing 70% of the medicine that you're selling. So that sounds like a narrower definition than some of the rumors that I've heard. Scenarios that come to mind where that would be put in jeopardy is if you have electrical failure, theft, something like that. I mean, you're like out of business that day, which seems unprecedented in any kind of an enterprise. So I'm wondering if there is any type of contingency being considered for that type of thing, because clearly a grow operation could be targeted for theft, and if that happened, you still had a period of several months until you could resume producing enough medicine to meet that requirement. Okay? Clearly, one of the main topics, or one of the things we need to work through rulemaking is the time frames associated with the 70-30. There's no doubt about it. It makes sense to me to tie that requirement probably to a growth cycle when your medicine is produced. We can look at the ratios, the inventory, but that's the kind of stuff that I need from the industry as a whole, and I recognize the peril that you described. For purposes, however, of the September 1 deadline, you will have to certify that you're growing 70% of your medicine. That's what the bill provides. Then we'll work through the rest of it through the rulemaking process.
What does certify mean? Is that something that you guys are coming up with, or do we have to come up with a process to demonstrate it?
The Department of Revenue will have on its website an affidavit. You'll just have to simply fill it out and send it in.
Thank you.
Again, guys in the back, if I could get the MMB staff to kind of help me control the noise in the back. There is plenty of room outside of this room if they want to have separate conversations. It's really important to get through this. Thank you. Go ahead.
My question is about the section 1284 that involves back taxes and outstanding student loans. Would you mind just clarifying that a little bit for us?
I'll take that one. As far as the back taxes and child support and student loans, what we're looking for is, or what we look for in the background is, and we have this in all of our industries, if you have, say, if you owe back taxes, and it's a big chunk, you won't have to necessarily go in and pay that big chunk on that one time. You can set up with most of these agencies, and as far as the child support, taxes, all these, an agreement to pay. If you come in with an agreement to pay, we may tell you that you have child support that's outstanding, because we're going to look. And when we look and we find it, we'll tell you to have it. We'll give you the option to go and a number to go do it with. Clear that up. As long as the county, city, or the Department of Revenue, whoever gives you an agreement to pay, brings you current, and you stay current with that, you'll get a license that's conditional on that agreement to pay. As long as you stay current with your promise, you will be able to continue with that license.
My question is concerning the background checks for employees of the dispensary, and what will be the standards to decide if they're good moral character if someone was to have a felony for cultivation of marijuana in their past. Is that going to forbid them from working in the dispensary in their growing capacity?
The statute's very clear as to what we call automatic disqualifiers, and unfortunately an employee is a licensee by definition, so there will be prohibitions, but I'm also going to tell you that there's a gray area there that deals with other kinds of offenses. If you have a felony in the past 5 years, it's an automatic prohibition. For sake of argument, you had something 6 years ago. Since then, you've never had any problems. Maybe you went to college, got an education, you paid your taxes, you're a good citizen and good standing within the community. All those kinds of things show what the statute refers